Hi guys, in this video I'm going to provide some background information about the authorization doctrine in Australia. The authorization doctrine is the law in Australia that means that intermediaries can be liable for copyright infringement. So I'll look at the basis for intermediary liability for copyright infringement in Australia, and I will also look at one of our most important cases in this area, which is University of New South Wales and Moorhouse. Okay, so the starting point for authorization liability is the Copyright Act, specifically sections 36 sub 1 and sections 101 sub 1 of the Copyright Act. These provisions provide that it is an infringement to do or to authorize the doing of an act comprised in the copyright without the copyright owner's permission or without a legal excuse or exception under law. So for those of you who haven't studied copyright before, just a little bit of background information to that. Section 36 is in the part of the Copyright Act that deals with what we call works. These are literary, artistic, dramatic, and musical works. So these are the things that you would traditionally think of if you think of traditional arts, like books, music, and visual arts, so paintings. Section 101 is in the part of the Act that deals with what we call subject matter other than works. And these are those items that are a bit newer in terms of technology. So these are sound recordings and cinematographic films are the relevant ones for our purposes. And section 101 is the section that tends to come up most in authorization cases on the internet, because normally the files that people are sharing through things like peer-to-peer file sharing services are for TV shows or movies, which are cinematographic films under the Act, or their songs, which are sound recordings. So section 101(1) comes up more often. So those provisions in relation to the copyright items they apply to each provide that it's an infringement to do or authorize the doing of an act comprised in the copyright. Now, an act comprised in the copyright basically means any one of the rights that the copyright owner has exclusivity over, has the exclusive right to do. And for our purposes, the most important of those are reproduction, so the right to copy a work, and communication to the public, which is generally the right to share something online. These are the rights that are normally implicated in the internet space. So that's the copyright background. The important part of these provisions is the reference to authorizing. So it's an infringement to do or authorize somebody else to do. And it's this authorize part which applies to intermediaries. And that's where we get the name of the authorization doctrine. So what does authorize mean? Cases have held that authorize means sanction, approve, countenance. So in other words, the courts have defined authorize by reference to its dictionary synonyms. Now there are some problems with this because they have not then gone on to define those synonyms, but I will come back to that criticism of the definition in a later video when we look at the Roadshow Films and IINet decision. But the important thing to remember for now is that that is the definition, sanction, approve, countenance, and we don't have too much more beyond that, and it is rather vague. So let's go to the case law to see how we can further clarify what authorization is. So one of the most important cases in authorization liability in Australia is University of New South Wales and Moorhouse. This was a 1975 decision and it involved photocopying machines. So photocopying machines were a fairly new technology back then. What happened was that the University of New South Wales had photocopying machines in its library, and the Australian Copyright Council What they did was they got a former student of UNSW to go into the library and photocopy an infringing portion of a book by Frank Moorhouse, and the book was called The Uncertainties Baby. And then the Australian Copyright Council essentially got Frank Moorhouse's permission to bring this test case against the UNSW, and they alleged that the university had authorised infringement by providing these photocopying machines in their library. Now, this decision was heard by a 3-member court, and 2 judgments were delivered. One by Justice Jacobs, with whom the acting Chief Justice, Justice McTiernan, joined, and the other judgment was delivered by Justice Gibbs. And the decision was unanimous. All judges held that UNSW had authorised infringement and was therefore liable, but the 2 judgments had different bases for their decision. So Justice Jacobs found authorisation on the basis that the university had extended an invitation to their users to infringe. So he said by providing the photocopying machines in the library, the university was extending an invitation to their users, to their students and whoever else was in the library, to come and use those photocopying machines as they saw fit. And this invitation was unqualified. The university had not done anything to indicate to its users that the photocopying machines were only to be used for non-infringing purposes. So they hadn't provided a notice about length of things that could be copied or the purpose for which things could be copied. They had tried, but they had provided the wrong notice. So they had put a sign on their photocopying machines or just above their photocopying machines with a provision of the Copyright Act, but the provision was the exception to infringement that related specifically to libraries and libraries' internal purposes like archival copying, and not to the actual users, which would have been the fair dealing exception for research or study. So they hadn't informed their users about the fair dealing defence. They hadn't supervised the machines. They hadn't done anything to indicate that this invitation was qualified in any way. They just provided the machines. And Justice Jacobs held that that was an authorisation under law. Justice Gibbs had slightly different reasoning. He held that the university had control over those machines, and they also knew or should have known that they were likely to be used for infringement. And with that control and with that knowledge, they had done nothing to prevent infringement. So the statement he actually said, and I'm just going to read it out because it's a famous one and it's an important one. He said, "It seems to me that a person who has under his control the means by which an infringement of copyright may be committed, such as a photocopying machine, and who makes it available to other persons, knowing or having reason to suspect that it is likely to be used for the purpose of committing infringement, and omitting to take reasonable steps to limit its use to legitimate purposes, would authorise any infringement that resulted from its use." So again, similar to Justice Jacobs, he looked at the fact that the university had not taken any reasonable steps to limit the likelihood of infringement. They hadn't supervised the photocopying machines, they hadn't provided notices, they hadn't educated their users, etc. Now, this statement from Justice Gibbs is a very important one. It has been quoted in pretty much every authorisation case that has come since Moorhouse, and it is really one of the foundational statements in our authorisation liability law. So it's important to be aware of it, and in the next video I will talk about how this statement has been codified in part in our Copyright Act. The important thing that I want you to take away from today is the emphasis that Justice Gibbs places on control. So he says, a person who has under his control the means of infringement. So here the means of infringement was the photocopying machine, and he believed that the University of New South Wales had control over those machines and how people could use them. And control, this idea of control over the means of infringement and how people use those means, is a really important idea in authorization liability law. And the courts will often, in